Next up.
Nancy Melcher, M-E-L-C-H-E-R, 3180 Don't Run Church Road, East Fallowfield, 19320.
And how far, ma'am, was that from the subject property?
Probably about a mile and a half.
I would reserve the same objection with regard to the mulcher included on party status.
Or anybody else? So seeing none, so the ones to which the applicant has objected or reserved the right to object would be Mrs. Scott, Mrs. Melcher, Mr. Wylam, and Mr. Cook. So just to remind everyone, you have the opportunity to submit something in writing prior to the next hearing as to why you believe you're entitled to party status. The applicant will have their opportunity to present their position as to why you are not, and the board will make the decision on that at the next hearing.
Can I sneak in at the end?
Sure. You don't need to sneak either.
Thanks.
So I'm Michael King, and I'm probably one of the closest people to the development, but definitely touching it, and I've lived next to that property for 28 years or so.
What's your street address, Mr. King?
107 Kathleen Drive.
And you say you're an abutting property owner?
Definitely.
And you live at that property, correct?
Yes.
No objection.
Thanks.
Seeing none further, we'll turn it over to the applicant to present their case in chief.
Thank you, Mr. Crotty. First off, ladies and gentlemen, my name is John Jarris, and I am the attorney representing the applicant this evening. I just want to say to you on this party status issue, we're not trying to single anybody out. It's a legal issue. This applicant, or any applicant, which could even include you at some point in the future, sitting in this chair as a conditional use applicant, is entitled to review people who request party status and determine whether or not they are what the law calls is, quote, a person affected, close quote. Through case law, the courts have established that you have to live in close proximity to be considered a person affected. So I hope you please take the objections as to those individuals we did, not personally, it's a legal issue that we're doing to protect the applicant. As I believe Mr. Crotty stated, I don't think anyone's going to be precluded from asking questions or making statements with regard to their particular position. But I just wanted to try and clear that air if I could. First off, this application is not new. This application has been around since the year 2000, for some 16 years now. Bawa Mujahideen Fellowship Farm Community has applied for conditional use approval in Fallowfield Township in conjunction with a previously approved agreement with the township. The settlement agreement dated May 22nd, 2012, which was marked as an exhibit by Mr. Crotty, and which I have marked as an exhibit for my client, the applicant as well, was essentially between the Township Board of Supervisors, the Township Zoning Hearing Board, and the Fellowship, and it permitted certain relief for the project to move forward through conditional use approval and ultimately land development approval in effect at the time the use was originally applied for, and that was the year 2000. So, a couple of rules that we're trying to abide by is, number one, this application that you see before you was thought about in a settlement agreement and was approved to move forward, and that's why we're here this evening before you, the Board of Supervisors, for conditional use approval. And number two, it's being judged by the ordinances in effect in 2000, not the ordinances in effect today. So, Mr. Crotty, I just wanted to try and get an agreement or a stipulation between the applicant and the township on those 2 points.
That's correct. Technically, it's the zoning ordinance of 1990 as amended up through January of 2000 is the applicable ordinance.
Very good.
What was the ordinance?
it's the zoning, the East Fallowfield Township zoning ordinance of 1990,
Yeah.
as amended through January 2000. Sometimes there are
Well, I
amendments
don't
through
know
the
what the
1990s.
ordinance was though.
It's the zoning ordinance, but it's the,
So what
it's the
is-
version of the zoning ordinance that was adopted in 1990, and then amended through the 90s up through January 2000.
What are the differences
And
between those
guys,
two?
you gotta make sure, remember, since we have a court reporter, you have to identify yourself for the record so she can make sure to take down your name.
Gene Manor.
Could I make a request? Could I get through my opening statement before we entertain any questions? You might explain it a little bit further.
That's fine.
Thank you. Just a few more points. The settlement agreement provided for the grant of a variance to allow the new residential uses to be served by on-site individual wells and on-lot sewage systems, as well as the grant of a waiver from cul-de-sac regulations, should the township desire the proposed roadway serving the residential uses not be a through road. In other words, be a cul-de-sac as opposed to a through road. Per the East Fallowfield Township zoning ordinance in effect at the time, the use was originally applied for under section 402.4, a planned institutional community, in accordance with section 1704.12 of the zoning ordinance, which permitted the use by conditional use. The fellowship and one of its the fellowship owns 108 acres made up of 4 tax parcels located in the southwestern portion of the township on the western side of Mount Carmel Road at the end of Fellowship Drive. The property is located in the RA Rural Agricultural Zoning District. Currently, the subject property is partially developed with 5 buildings located in a cluster around the end of Fellowship Drive in this area. In the eastern portion of the site, the existing buildings consist of a garage, a pavilion, a camp kitchen, a bathhouse, and a mausoleum. The fellowship proposes to remove the existing camp kitchen and bathhouse and construct a fellowship farm community comprised of both residential buildings and religious uses. The residential uses will consist of 23 single-family dwellings proposed on approximate 0.7 acre properties, or approximately 3,000 square foot lots, clustered on approximately 19 acres along the northern tract boundary, as well as the existing mausoleum, the existing pavilion, the existing garage, and an existing cemetery. In addition, the fellowship plans for a new maintenance building, a new garage, a new rectory, a new house of worship on approximately 12 acres of the property. And you'll hear more testimony about this momentarily in more detail. The rest of the site, the balance of the 108 acres, which is approximately 75 acres, which will not be developed, will be left in its natural state, agricultural land, and preserved as open space. And as I stated earlier, the site is proposed to be served by on-site water and on-site sewage systems. Now again, we have 4 witnesses planned for this evening, a representative from the applicant, Mr. Charles Ginty. We have our civil engineer, Mr. Dave Gibbons, from D.L. Howe and Associates. We have our professional planner, Mr. Babbitt, David Babbitt and Associates, who will talk about impacts of the proposed development. And lastly, we have Mr. John Carullo of Carullo Associates, our traffic engineer. Most of the testimony is going to be coming from our civil engineer with regard to details of the proposed development. But with that, then, Mr. Crotty, if you want to entertain any questions with regard to what I've said, I'm more than happy. We're ready to move forward with testimony from the witnesses.
I think it's probably appropriate if anyone has questions about the details that he said, what's being presented, take note of what your questions are, and as their different witnesses come up, I think that's probably most appropriate, because that's what's going to be considered evidence, for you to ask them of their witnesses.